taking the deposition of the expert witness. The deposition of an expert witness is a bit different than taking the deposition of a typical fact witness. When I'm deposing a fact witness, I am generally trying to learn what their base of knowledge is. In other words, those fact witnesses, that is, witnesses that have facts which may be related to the case, are being deposed so that we can learn, we can discover what information they have. I am trying to learn where they were. What did they see? How is their information going to be related to what I'm trying to prove or disprove? I am not looking for some sort of technical opinion, but rather I'm looking for, did they see the color of the light when the car entered the intersection, if it were an accident case? If it were a case involving a breach of contract, what facts or information do they know that would help to prove or disprove that there was a contract, or there was a breach of contract, or there was a payment? As you can see, what I'm doing with taking the deposition of a fact witness, which is different than an expert, is looking to their base of knowledge, how they fit in to the equation, how they lend either support to prove or disprove some material fact and issue, whether the crime occurred, whether the person who's the defendant is the person who was involved, whether in a civil case, a breach of contract, a tort, an act occurred which they may have knowledge of. I'm trying to learn what kind of documents they may have created or read. I'm trying to learn what exactly they know. Now, in an expert witness situation, the expert witness is generally someone who was not necessarily there at the time of the event, but rather somebody who we bring into the case, who has some specialized knowledge that enables you to give more explanation to the jury about something scientific, something which has an underlying methodology that is beyond the average knowledge of a layperson, a normal person like you or me. So that expert, like a doctor, like an engineer, like a crime scene investigator, like a toxicologist, a blood spatter expert, they are providing their expert opinion by taking facts which are presented to them. Not facts which they know, which they observed at the time of the event, but rather facts or information which they observed either well after the event or those that are being told to them. So if I'm investigating a murder and I have somebody from a crime scene investigation unit or a blood spatter expert or somebody who has experience in firearms, they are either going to the scene after the event has occurred and evaluating evidence and coming up with scientific conclusions that will aid the jury, aid the judge in understanding what occurred, in understanding what that information that was evaluated means. Was the person drunk? Was this type of picture or this type of showing of blood indicative by experience of a way in which somebody was killed? Did the particular firearm match the exact gun from which it was fired by the defendant versus some other gun? These kinds of things are generally testified to by someone with a specialized expertise. You and I might not be able to testify as to whether or not a particular firearm discharged the bullet that they found, because we don't have specialized knowledge. We don't have a degree. We don't have that expertise. But a firearms expert, somebody who has knowledge in that area. If it was about a killing and we were talking about how the knife went in or how the blood that splattered tend to show that a killing or a stabbing occurred in a certain way, that is for the realm of the expert. Now you have rules, that is civil rules and criminal rules of procedure that govern how this type of evidence is presented. For example, if we were to use the federal rules starting with the 700 series, 701, 702, 703, in a federal system, many of which are adopted by state courts in some capacity, like Florida has 90.701, 90.702. These type of rules will help the judge to determine what kind of evidence is appropriate for expert testimony. For testimony by somebody who is qualified in a specific and recognized field to testify about a methodology, a part of science that is recognized in that field. So if you have someone who is a specialist, for example, you have a driving while intoxicated, a DWI or a DUI, there are certain devices like a breathalyzer that are used to determine the level of the person's alcohol content by breathing into an instrument. And if there is an expert that used that instrument, that expert may be there to testify that that particular type of instrument is an appropriate instrument, has a scientific basis behind it to test properly what somebody's blood alcohol level is, or alcohol level, or level of drunkenness is by taking something like the breath, or if it was a blood alcohol test, like your blood, and then evaluating it pursuant to accepted scientific methodology. So that explains to you how the purpose of an expert plays a role in this trial procedure, in this pre-trial analysis, in this gathering of evidence that will tend to prove or disprove a particular fact at issue in a civil or a criminal case. The discussion today is about taking the deposition of such an expert and how you approach that and the types of questions you might ask to gather the proper information in a case.